Good morning, everybody. Thank you so much for joining us this morning for our employment law webinar. Obviously, we have a lot to talk about today. Many changes happening here in Colorado, and we're thrilled that you all joined us to learn a little more and make sure that your business is running in compliance. My name is Cami Welch. I'm the president and CEO of the Arvada Chamber of Commerce. Also joined this morning by Daniel Riley, who's the executive director of Arvada Economic Development Association. And we are pleased to be hosting this event on behalf of the Arvada Resiliency Task Force, which is a collaborative group of local partners that have the interests of our business community in mind. We started our work during the pandemic and are continuing it to make sure that we have the strongest, most effective business community in all of Colorado. So we're so glad that all of you joined us for this important discussion. Just a couple housekeeping items for you as we go through today. We are going to do our very best to answer your questions live during the presentation. Obviously, again, there's a lot of information that we're covering, but if you're willing to drop your questions in the chat, I will be monitoring that and helping our amazing presenters stay on track with getting those answered. If they do come in floods, which they may, we may have to push that to the end or grab those and do a follow-up document to get your questions answered. So we're going to do our best to manage all of that. Additionally, right now in the chat, I'm going to go ahead and drop in the slides for today so that you have them to be able to access during the presentation and after and take notes if you so desire. With that, it is my pleasure to introduce you to our speaker today, Chuck Pasalia. He is with Employment Law Solutions. Chuck is an employment attorney. He was a judge advocate on active duty in the United States Navy, a litigation attorney with Moy Gillies, which is now Moy White in Denver, and an in-house employment law counsel for Mountain States Employers Council. In 2003, he founded Employment Law Solutions, Inc., a consulting firm in Denver, Colorado, which specializes in providing employment law and human resources advice and counsel, impartial workplace investigations, and entertaining courses for the entire workforce in critical compliance matters, including harassment and violence prevention, ethical decision-making, paying employees properly, and managing employees' absences and protections under federal and state anti-discrimination laws. It is my pleasure to introduce you to Chuck. Welcome, Chuck.
All right, Cami, thank you. And thanks to you and Daniel for allowing me to do the program. And thanks to everybody for joining us today. It's, as Cami suggested, there's so much that's gone on in the last year. It's probably not lost on you if you work for a business, and certainly if you own a business, that the circumstances under which we live here in Colorado are ripe for regulation. And so I expect more during the current legislative session. But in this session, let's talk about what's happened over the last year. As Cami suggested, I encourage you to drop your questions into the chat. Please keep in mind that if you don't get your question in today, you can always reach out to me by phone or by email and ask a question after the program is over. Cami has been great about supplying the materials, so please jump into the chat function if you want a copy of these slides, want to review them on your own time, or you want to socialize them with other people that you have business interest with. So let's talk about our topic today. Let me show you where we're going to go. We've only allowed an hour, which amazingly enough, even though I talk fast, it might be pushing the limits of what we have to talk about in this year's session. So I've had a chance to do this in the past, and we try to emphasize what's happening here in Colorado. But this year, I'm going to start with a little bit of what's going on in the federal government, because a similar circumstance occurred last year in federal lawmaking. I want to talk a lot about things that business owners should appreciate that occurred in last year's legislative session. I want to talk about some things we've discussed in the past, and then it's the evolution of Colorado's rules. And then if we have some time, I'm going to talk about the way ahead, where courts are stepping in to address employer-employee relationship issues. And then we can't end the class without talking a little bit about the active Supreme Court, U.S. Supreme Court, and the way that they have shaped the workplace as well, and will continue to do so, by the way. So let's talk a little bit about how we're going to go. I like to look back because our time is so short in the last year in very short perspective. If you haven't been at work or anywhere in the last year, let me just kind of tell you what happened. And I'm sure most of you already know this. So the big issue was COVID, and the Supreme Supreme Court limited employers' ability, and certainly the federal government's ability, to mandate the COVID vaccine. An OSHA rule was defeated. Healthcare workers are still subject to mandatory COVID vaccines, and that's still a work in progress. In addition, the federal government was very active in its rulemaking, but while they promised us a new overtime rule, keep in mind that we're regulated as employers. If employees work sufficient hours, more than 40 hours a week, they may be entitled to overtime. In addition, they were going to address the salary level for exempt employees, who are exempted from overtime, but that has not yet materialized. And of course, things that will not surprise you are, number one, the poor economy and how businesses were driven, including driven to layoffs, and the requirements for giving notice of that. The incredible politicization of our country, that we seemingly can't agree on anything any longer, and how it affects workplace relationships, and then very active state legislatures, including Colorado's, addressing things like pay transparency, a law we already have in Colorado, and expanded time off, including issues in California now demanding bereavement leave, and consideration of leave in the wake of the U.S. Supreme Court overturning the 50-year-old Supreme Court ruling in Roe versus Wade, addressing the issue of abortion. So I wanted to set you up for a conversation to remind you that a lot is going on in the country. And in many ways, we haven't resolved many of our conflicts over critical issues affecting Americans, which goes to a few federal laws that I want to talk about. You may have caught this at the end of the year, but in the change of the House of Representatives, there was a very active effort to try to push through some legislative initiatives before the House of Representatives came under Republican control, as it now has. So a couple of these things are sort of important, and I want to talk about them. The first one is, it is now federal law that employers cannot bind employees to confidentiality and non-disclosure provisions in cases of sexual assault or sexual harassment, certainly before any type of problem has manifested itself. In other words, if you do resolve cases involving sexual harassment, you are going to have to comply with this particular law, which says essentially that you can't limit employees' discussion of the circumstance of sexual harassment or sexual assault in the workplace. So just remember, if you do face a sexual harassment claim or case, you are going to have to navigate this law, because these particular cases will more likely see the sunshine and be open to public attention, as opposed to efforts to try to conceal them in the form of a release agreement. That doesn't affect every employer, but I do want to remind you about this. Next issue, in the wake of overturning of Roe versus Wade, a case last summer called Dobbs versus Jackson Women's Health, a concern was raised about whether the Supreme Court would go back and review previous rulings, some of which were founded on some of the same principles that Roe versus Wade was founded. So Congress has made an effort now to make very clear, not guaranteeing the right to marry, but making it very clear that all states have to recognize a valid same-sex marriage. This is the product of reinforcing a Supreme Court decision from 2015 called Obergefell. But just to remind you, this was a circumstance where people had varying issues about same-gender marriage or even interracial marriage, which has also been affirmed by the U.S. Supreme Court. It's now codified into federal law that same-sex marriages must be recognized, interracial marriages must be recognized. There is an exception to protect religious institutions. Obviously, they're bound by their own religious edicts. And the Respect for Marriage Act makes very clear that polygamous marriages, being married to more than one person, are not lawful or recognized in the United States. So that's just reinforcing existing law in the United States. Next one, and it's important to remind you about this, and again, I go quickly, is Congress passed within the massive spending bill Congress passed the Pregnant Workers Fairness Act, or PWFA, and the PUMP Act, which is providing urgent maternal protections for nursing mothers. These two provisions already exist under Colorado law. So Colorado already requires, and I want to remind you of this because now there's federal protection on top of Colorado protection. Colorado law and now federal law require all employers, and by the way, in Colorado, it's all employers, to potentially accommodate employees during the course of their pregnancy and childbirth. I'm sure you likely already know that, but I want to bring renewed attention to this, is the requirement to accommodate pregnant workers and new mothers. The PUMP Act is also part of Colorado law, where employees have the right to take time during the day using reasonable break periods to express breast milk for a newborn child. In Colorado, a newborn child is defined under this law as up to 2 years. So please remember, federal law simply reinforces existing Colorado law, allowing for pregnancy accommodation and the lactation rights of working mothers. So I want to bring renewed attention to those in the wake of Colorado law. Next thing is changes in retirement plans. If you have a retirement plan, we'll talk about this again in just a moment. If you have a retirement plan, then the Secure 2.0 Act is part of, again, this omnibus spending bill that does a number of things that streamline participation in employee retirement plans. I gave the 5 critical issues. Perhaps the one that's most interesting to people who are employees is the notion of increasing catch-up contributions into these plans and raising the age for required minimum distributions. It's presently age 72. You might remember a couple of years ago, it was raised from age 70 to 72, and now it's going to incrementally increase to age 75 over the course of the next few years. So it allows people to not be required to tap into their retirement savings until a much later time frame and in accordance with their own plans. So please review this with your own benefits experts, your own benefits plans, but there are changes, most of which start in 2024 and into 2025. But it's important that you recognize that fact. Other things about COVID regulatory issues is if you're going to require employees to receive a COVID test, and by the way, you should be doing this anyway in terms of complying with the law. In terms of requiring an employee to receive a COVID viral test, determine whether they have COVID-19, you have to follow the ADA's rules, meaning it has to be job related and consistent with some business reason. So I know you're already likely doing that. If you still require COVID-19 tests, you're going to have to tie a business related need into requiring your employees to receive a COVID-19 test. Do want to remind you, this has remained the law, is you cannot require an antibody test, a test to determine whether an employee has sufficient antibodies, they're superhuman enough to withstand COVID-19. That would be a prohibited medical exam under the ADA, our law protecting disabled individuals. I'm going to keep on keeping on. And then I do want you to know there is actively in the works, and this is important for any employer, including any employer in Colorado that potentially hires independent contractors. The Department of Labor is considering rescinding a Trump era rule that really liberalized the definition of an independent contractor. They're considering narrowing who is an independent contractor and raising the bar, if you will, to prove someone is an independent contractor as opposed to an employee. This is likely to generate significant litigation because it may well change who may be an independent contractor working for you or doing work for your business. And it's going to have a significant impact on so-called gig workers, people in the gig economy, who are working jobs that we all know are typically classified contractor jobs, such as Uber drivers, things along those lines. So stand by, see where this goes, but it may affect who is or is not an independent contractor in your organization. Still out for rulemaking consideration and has not been enacted yet, but is certainly likely to be a topical issue in 2023. All right, let's keep on going. You did great. Want to make sure I talked about that. Now I want to dive quickly into some Colorado law considerations for any business that has to think about preparing for work in 2023. You probably are all well aware, and hopefully you have addressed in your individual businesses, Colorado's Paid Family Leave Act. Want to talk a little bit about the requirements of this law. Want to talk about what you should have done by now, and certainly if you haven't done by now, you should think about doing in order to comply effectively. So you might remember, in fact, for those of you who know me, and I recognize some of the names of our attendees, we talked about this in a session here for the Arvada Chamber in 2020 about Colorado's adoption of paid family and medical leave. And interestingly enough, this is a law that takes the Federal Family and Medical Leave Act, which is our nation's leave law, which only applies to employers with 50 or more employees, takes our nation's federal leave law and it grafts it on all Colorado workplaces. And now all employers subject to this law are not only going to have to provide 12 weeks of family leave, but it's a funded or paid leave funded through an unemployment type system in which employers and their employees will pay premiums taken out of employees' paycheck. What's significant about this law is it tremendously expands the federal FMLA. One, it makes it paid, but it also provides for additional leave benefits. For example, instead of giving just 12 weeks in a year for qualifying events, it gives 16 weeks a year for pregnancy and childbirth or childbirth related issues, such as complications from childbirth. It also adds a provision not found under federal law, and that is so-called safe leave. What I mean by safe leave is now a right under this law to take up to 12 weeks off to evade a domestic aggressor, to get resources, help, flee an aggressor, obtain judicial intervention or law enforcement intervention if an employee is a victim of a domestic aggressor. So I do want you to know this is an expansive type of leave protection. You'll note it covers all employers in Colorado with at least one employee. A couple of exceptions I want to talk about in just a second. Why that is important is the deductions, the premium deductions required to fund this provision started on January 1st and must be made from employees' paychecks effective the first paycheck following January 1st of 2023. The leave doesn't become available until a year from now when the fund, the Paid Family Medical Leave Act fund, has sufficient resources, money from these premiums to pay out through the Family Leave Fund employees' absences. We don't pay that. The fund pays that, similar to unemployment insurance. A few rules about who gets it is essentially employees have worked for you for at least 180 days, earned a threshold amount of $2,500 in those time periods. This law runs concurrently with the FMLA. I do want you to know that. So if you already have 50 employees and you already follow the FMLA, this law runs concurrently with that. And Cami, thank you for reminding people and me in the chat. If you have any questions about this, please jump in. I talk so quickly, and you can read this as fast as I can talk about it, but I really want to make sure I don't blow through any very important questions. And I'll pause at the end of this slide set so we can take some questions you might have about paid family leave. A couple things. So it does run concurrently. If you have 50 employees and you already follow the FMLA, This law streamlines with it. What is really interesting, though, about the FMLA is, please keep in mind, under federal law, employers can require that employees use accrued paid leaves, running them concurrently with family leave. Now, since employees are going to be paid out of a fund to finance their family leave, employees can't be required to use their accrued paid vacation or sick leave unless they decide to use those paid leaves to supplement their paid family leave. And an employee, as you can imagine, may well desire to do that. Does add an administrative burden for people. Like talking about this, I have a pretty small practice. Losing an employee for 12 to 16 weeks can be a hardship. Is there any grant or assistance to an employer during that time? Great question. And the answer is no. There is no emergency or undue hardship exceptions to this law. You can imagine that very small employers are going to be potentially constrained by this. Now, I'm going to talk about very small employers. If you have less than 10 employees, it's going to be a different issue. But there is really no assistance. And that's why the concern about this law is, what is going to be the hardship? You can imagine why I like the question in chat in this regard is, this requires some intention, some forethought on your part. Anybody can take FMLA leave. And what I mean by that, I'll talk about self-employed persons in just a second, is in a small workplace, half of your workplace could take paid family leave. And that is going to cause a potential difficulty for any small business, because there's no limitation on half of the workforce or more taking FMLA under these rules. Question was asked about, please provide more details regarding the self-employed individual within a corporation. Yes, this law does allow people who are self-employed. Myself, I have my own practice. It allows people who are self-employed to opt into this system. And so you can actually finance and obtain this benefit even if you are a self-employed individual working in your own capacity. And so it's important that people recognize that fact. Talk about that funding. I mentioned earlier, the leave is funded through this payroll tax. Employers and employees share the burden equally, although employers could choose to pay the employees share the premium if they so desire to do so. Did want to talk a little bit about who can opt out, and you may have already done this. Do you need to wait until he works 180 days to withdraw premiums? Is you don't necessarily need to do that. Obviously, you're eligible once you reach 180 days, but any employee and any new employee could have their premiums deducted from their paycheck starting January 1st of 2023. Who can opt out? And it's important that you understand this. Very limited. So local governments, for example, the city of Arvada could elect to opt out of this provision, and private businesses that already have a paid short-term disability benefit. This is important, and hopefully you've talked about this over the course of the last year, is if you already provide a paid leave benefit through a short-term disability benefit program, and there's a number of these available on the open market, then you don't have to opt into this system. But you did have to report to the state what your decision making was in this regard and give details to that to the state. And you should have done that already. I'll talk about that in just a second. And so my CPA says she's going to make quarterly deductions to employee paychecks for family. Is that okay, or should it be coming out of each pay period? There appears to be no limitation on when, as long as you take the premium payments, doesn't appear to be that it's required out of every paycheck. And so that may be reasonable, at least reading these rules. And there are rules with regard to this, but I don't believe that is a constraint. As long as the premiums get paid to fund this, they don't necessarily need to be taken out of every particular paycheck from an employee. What's interesting about that, though, is, of course, the open question about whether you're going to lose employees' premium payments, meaning employee starts, they're working, and they quit or they're fired in between these quarterly payments. That leaves an open question for me about how the state would view that. But I don't believe it's necessarily a violation of Colorado law to make these deductions on a periodic basis. That's a good question. Always look to the rules on that, though, because these rules are complex. I should note, if you have fewer than 10 employees, and there are some people new to this program, if you have fewer than 10 employees, then the employer doesn't have to make the 0.45% deductions. The employee still has to get their payments out, but smaller employers are exempt from deducting their share of the premiums. And that may be a few of you listening who are responsible for complying with paid family leave. And by the way, these questions are fantastic. Please keep them coming. They're great. That's why I like our opportunity to talk. Local governments, I'm not going to mention this. I don't know if there's any local governments who are listening to this program. And certainly if you are a local government, you should have already made your decision and notified your employees whether you're going to participate or decline participation, or allow employees to participate of their own accord, which are the three choices. But employers should have notified of their decision before January 1st, or they will be treated as participating within the system. So here's what I wanted to talk about. So, another question. We're a business with 7 employees, so my employer doesn't have to contribute, only the employee. That is correct. Employer could choose to do so, but they're not required to do so if you have less than 10 employees. So employee contributions are made, but not the employer matching contribution. By the way, employees still get to participate in the system, but the employer doesn't have the additional matching responsibility if you're a smaller employer of that size. So here's a couple things I'd like to talk to you about. And obviously, this is why I really appreciate the timing of this session, is one, you should have already been registered with family. You should have made your decision, determined, should have already considered what these premium liability is going to be for your employees and budgeted for that. This was the concern, is wait a minute, employees now are going to get 0.45 in addition deducted out of their pay. And so some employers have addressed that in terms of how are we going to properly compensate our employees if we're going to take an additional amount of their paycheck that the employee may see and wonder, and may not necessarily desire this to be taken out of their pay. It is a requirement. So employers are potentially addressing what is the proper compensation for our employees in light of these additional deductions that are now being made. But what I hope you've done is 2 things, really 3 things. One is you've notified your employees about this, that deductions are going to be made. And in addition, you've complied with the notice responsibilities. And what I mean by notice responsibilities are, number 1, there is a required poster, which is available from the family division. If you just Google Colorado Family Division, you can find that new agency of government, and they have the poster available. But I also hope, and this is really important about these sessions, please understand, you should be considering right now, this goes into effect in 2024. If you have an employee handbook or policy guidance, you should have a paid family leave policy to educate your employees about their entitlements under this law. You may not have to have it immediately, but you certainly should have it by January 1st of 2024, when employees will be entitled to this time off. So please consider handbook provisions if you have a handbook, and incorporating this particular benefit into it. Any questions about paid family leave in addition to the ones we had in chat? I'm always curious about that. I assume a lot of you have already been contemplating this, but I want to make sure that you're talking with your accountant, you're talking with your human resources about complying with this newfound responsibility. For postal requirements, how do virtual companies deal with those requirements? There is no lunchroom. It's a great point. Actually, Colorado law, it's a great question. I appreciate it. Colorado law now allows for the electronic transmission of these posting requirements in consideration of remote labor, of the remote workforce. So you can electronically communicate these posted requirements, or you can post them on your website for employees, especially if you have an employee website, where employees can log into the organization's website for some use and functionality. You're allowed to use electronic means to communicate these posting requirements. So that's a great question, and I appreciate you bringing it to everybody's attention. All right, I'm going to keep on and keep the questions coming in chat. They're fantastic. I want to talk about another requirement in 2023 that's caught a few people by surprise. You may also remember we talked about this a few years ago. That's why I appreciate our long-standing relationship, is that Colorado passed the Secure Savings Act. And so this is, again, a 2020 mandate, which requires employers that do not have existing retirement plans to now initiate a retirement plan for employees. Who's covered by this law is impressive. It's any employer with 5 or more employees. It's been in business for at least 2 years and doesn't have an existing qualifying plan. So some of you listening right now, you can tune out for a little bit because you already have a 401k, 403b, you already have an existing retirement savings plan available to your employees. Whether they choose to opt into it or not, is you already have that. This is for the employers. This is typically smaller employers that don't have. Are there any exemptions for nonprofit organizations? Not to my knowledge. It's a great question. Haven't seen that in the statute. Haven't seen that in the program. These are the compliance responsibilities. Just these 3 is 5+ employees, 2 or more years in existence, and don't have an existing plan. That would include nonprofit organizations, in my estimation. Have a simple IRA already in place. However, we just match 3%. Do we need to increase the match to 5%? It's going to be an issue because Colorado law does now increase the matching provision. Going to have to check on that. And I don't know. I mean, obviously, the question for me is you already have a plan. So I would argue you're not covered by this. But interestingly enough, please keep in mind that Secure Act, which does have matching requirements, the Secure 2.0, the federal law, has matching requirements that are going into place. So Steph, you're going to have to check that because that does have mandated matching responsibilities. And then the question is Colorado going to require similar matching? You'll notice why the question is great is that once enrolled, employees have the opportunity to opt in or opt out. If they opt in, they can customize. And what's interesting is Colorado employs an automatic 5% withheld on an after-tax basis. And that is important. People understand that. What's interesting, though, is Colorado doesn't have that match requirement, which is Steph's question, but federal law may do so. So employees are going to fund their own retirement in accordance with this plan. So what I wanted you to know about this is a work in progress. So I wanted you to be attentive after this. This is what the Colorado Secure Savings Program has published, is that the state of Colorado is going to send every Colorado employer a notice to register into this program if they do not have an existing retirement plan. You're going to register. After you receive the notification, you have 30 days to apply for an exemption. Now, again, this goes back to the question that was raised earlier about nonprofit organizations. Don't have significant detail about exemptions other than, hey, we're smaller than 5 employees. We have an existing qualifying plan. That goes back to the question that was just raised in that. We already have a simple IRA. I don't have to follow any of this. And so in the example given in chat, you may want to consider an exemption from this plan. so you can manage your own plan outside the constraints of the Colorado Secure Savings Plan, because you have a simple IRA, which seems to be qualifying for an exemption. You'll notice, Steph, at the bottom of this slide, if you have a tax qualified retirement savings plan in place, including a simple IRA, for example, I have my own business, which has a simple IRA as well, I'm exempt from this secure savings program. But if you do not have any type of retirement savings plan, then you are going to have to register within the time frames that are given. You'll notice the smaller the employer, the more time you're given to consider your options in this regard. But I do want to emphasize, if you don't register or apply for an exemption, there is a penalty under Colorado law for not complying with the registration requirement. All right. Always check your microphone too, just so people know. Just a couple things, check your mic. Next steps for me. Do we have to offer a retirement option, but employees can opt out of using it? Yes. That's the thing, is you have to have a retirement plan, but employees can absolutely opt out. I mean, the law does not require, even though of course it's a great thing, obviously, for people to opt into retirement savings. You can't compel someone to opt into a plan, because remember, it is going to take money out of an employee's paycheck to fund this plan. So employees will always have the right to opt out should they desire to do so. Good question. I want to be clear about that. Here's what happens. So that's why I love the question. Here's what the secure savings plan says is, if you don't have a plan, then you're going to have to notify the state of your any payroll vendor that you use, your payroll schedule, who your bank information is, and a complete employee roster. And the state is going to automatically enroll people into that. Then you're going to have to determine whether your employees opt out or not. So it's a mandatory opt-in system until your employees opt out. So please keep that in mind. This might be a point of communication with your employees. They're going to be opted in and given 30 days to opt out. That is going to require you to communicate to them their opportunity to opt out under these rules. What's really important about this is that you can't give any retirement advice, tax advice, savings advice. The W-2 is apparently going to come out of the state, and so through the program, rather than you having an obligation to make these W-2 notations. I just need to have a retirement plan. Is 0 employees opt in? Am I still compliant, correct? The answer is technically yes. You just have to have a plan. And it's conceivable that every employee could opt out. You, of course, can't force them to opt out. But if no one opts in, then you are compliant. All you're going to have to establish there is that those employees that you have opted out. And that should not be difficult to make that determination. But here's the key to your question. The burden's on you to demonstrate that the employees opted out, and that's important. Can smaller employers opt in? And so smaller than 5. Now, that is a question that is unknown to me, that the only people required to follow this rule, but I guess to me as a practical comment, is any size employer can adopt a retirement savings plan. I gave the example. I am my own business of 1 employee, and I have a simple IRA, a simple employee individual retirement account. And so any employer of any size can opt into a retirement savings plan, and there are a variety available. And so it doesn't have to be this one, but there's certainly tax advantages to having a retirement savings plan. So you may not need to be in this plan if you desire to adopt a retirement savings plan, is what I'm trying to communicate. That's a good question as well. Any questions? I'll just go back to this. Any questions about secure savings? What I want you to remember in this session is this notion that you should be getting notification sometime soon about this. And it's important that you pay attention to it. And if you see anything with secure savings come across your desk, That's going to be the notification which triggers requirements for you to consider. Do you have a plan? Are you going to ask for an exemption? Are you going to communicate to the state? Is the Secure Savings the retirement plan that the state provides if employees do not already have a plan set up? Yes. So Secure Savings is this state-sponsored retirement plan for individuals that work but do not have an existing plan set up for their employer. And so it is the retirement savings option for those employees in Colorado that do not have an existing retirement savings plan. The whole intention, of course, is to encourage people to save for their retirement. And that's why this plan exists. Again, these are great questions. All right, for a few more minutes, we're doing great. Let me talk about new laws. As I said, I want to talk about things that are really, really important for you. And this is going to spend about 10 minutes. And then hopefully we'll talk about a few things you should know. And then take some time for questions. So these go dizzyingly quickly. If you use non-competition agreements, there is now a significant restriction on the use of non-competes. Keep in mind, non-competes in Colorado have always been subject to scrutiny. They're void, except under very limited circumstances. But what's the news here is Colorado law now eliminates non-compete agreements which were available exclusively to limit your executives or professional staff from competing against you. And we could bind executives to non-compete agreements based solely on their status as executives or professional staff. That has been eliminated. Now, the only really effective way to bind any employee to a non-compete agreement is you have to construct a non-compete agreement to protect your trade secrets, which demands that you have trade secrets and you hold information as trade secrets or business practices. So you're gonna have to prove you're protecting trade secrets. And in addition, it's only for highly compensated employees, which is people that make more than $100,000 a year, 101,000 and some change. So significant limitation. You may have read in the paper that this week, the Federal Trade Commission has just proposed potentially making all non-competition agreements unlawful. Doubt that's going to necessarily go into place. Certainly to be subject to litigation, but this is part of the reinforced effort to try to limit non-compete agreements in the workplace. If you're going to add a customer non-solicitation agreement, hey, you can't go out and solicit our customers. You still have to have that trade secret protection, and you have to be for at least mid-range compensated employees. And so it's important, if you're going to limit any employee's ability to compete against you or solicit your customers, you're going to have to follow these newfound rules. At least one benefit of the statute is they didn't touch the other two exceptions allowing for non-competes. If you sell your business or you purchase a business, you could bind the seller to a non-competition agreement, and you can still do so under Colorado law. And we can always have agreements with our employees to recoup reasonable training expenses over a period of time. So for example, we paid $30,000 to train an employee. They have to, if they leave within a set period, 2 years, we can have a provision that requires them to reimburse us for those training expenses if they leave in a very short period after they started. And now they're going to take that training cost somewhere else, the training benefit somewhere else. So I wanted you to know about this. It's a big deal. I would encourage you, if you have non-competes, they should be reviewed by legal counsel. We expanded Colorado's anti-discrimination law. Here we go. It's in the question. We offer IRA 6 months with 3% match. Do I need to offer retirement at the first 30 days and then just don't have to match until 6 months? No worries. It doesn't appear to be the case there, is you don't have to offer it any earlier. In fact, only employees that work for 180 days become eligible for this requirement. And so it doesn't appear, I think you're 6 months. actually sounds reasonable to me. Is there a minimum cost spent on training for that to be valid? There's not, and thank you. There's not a requirement under Colorado law for an agreement to reimburse training expenses. There's no dollar limit set forth in the statute. How does this exist pre-existing non-competes? It's a great question. This law goes into effect went into effect in August. Apparently, it does not impact pre-existing non-compete agreements. So those are still in play. Of course, the real question there is going to be, if you try to enforce one of those pre-existing non-competes, what's going to be the judicial temperament about how to examine that? But it's only non-compete agreements moving forward. And so I did want people to know that. Although, again, please remember these constraints. Now under Colorado law, you have 300 days to complain of discrimination. It used to be 6 months. And so they've expanded that protection. Domestic service workers, if in private employment, can bring claims of discrimination. And then we've added punitive damages to discrimination based on age discrimination. Not necessarily relevant that you have to know that. This is one you have to know. Remember when we spoke in 2020, we talked about a new protection, and that was Colorado's public health emergency whistleblower law. It was called PEW, which I always like the name of. They liked it so much, they went back for more, and they expanded Colorado's public health emergency law to protect. And by the way, this is essentially any employer with 5 or more employees is covered by this protection. Now, our public health emergency law covers any public health emergency and any health or safety concern. And so even if you're not covered by OSHA, which is the federal law that protects employees' health and safety, this law is a mini OSHA. It allows any employee who works for an employer with 5 or more employees to express any concern or blow the whistle on any health or safety violation, not just COVID-19, not just public health emergencies, and be protected from retaliation or reprisal for having done so. This is must-learn information for any employer operating a business in Colorado. We now have an expansive whistleblower protection for any health or safety-related concern brought by an employee, and it must be addressed, and an employee cannot suffer any harm for having raised a health or safety concern in the workplace. And that's a big deal. Keep on going. We now have the False Claims Act. This actually is a law that protects against fraud against public companies or use of public funds. We have a requirement now. This is another big deal issue that I wanted to apprise you of. You probably were well aware that in Colorado, there was not previously any requirement to give an employee written notification of the basis for their termination. We could fire employees and we're not required to inform them in writing of the basis for doing so. Now they amended our unemployment statute to make very clear that we have to notify employees at their termination, whether they quit or are fired, of the reason the employee separated from their employment. There is, if you're interested, under the Colorado unemployment website, a standard notice that can be given to employees, which includes the reasons for their separation, which does comply with Colorado law. This went into effect last year. You should be complying with new Colorado law that does require you to give a form to your employees of the reason for their departure. Now, not surprisingly, most employees quit rather than they're fired, and the reason would be they're quit. The form is on state. If you go to the Colorado Department of Labor and Employment website, www.cdle.org, and look at the unemployment tab, you can find that form there. I do encourage it. I should have included it actually in the package here, but I do want you to be able to find that form. It is required now under Colorado law. We do a few more. Wage theft. This is important. We reinforced the penalties for not paying employees their wages, including wages upon termination, in a sufficiently timely manner. And so if an employee makes written demand for wages, it increases their penalty. But perhaps the most important provision here is this ability to deduct for unreturned property is now further restricted. You are going to, if you're going to try to reduce an employee's final wages for unreturned property, tools, equipment, computer, you have to now follow Colorado law within doing so, including giving a specific notice in writing, accounting for the equipment or property and its reasonable value, and when it was provided, and the fact that the employer believes that the property should have been returned or paid money in its place. So you're going to have a written agreement for any property that you extend your employees for their use, that you expect to charge them for if they fail to return it upon their departure, whether that's equipment, tools, computer, etc. That goes into effect on January 1st, which of course we're just into the new year. Please know that. So the property, how do you provide a paycheck in 24 hours then? It's going to be the issue is this is going to be the tough thing, is keep in mind, if you fired this person and they haven't returned your property, you're going to have to give them notice immediately that you believe they have unreturned property, and you are going to notionally withhold that in terms of complying with this provision. It's going to require very expedient measures on your part so you don't violate Colorado's wage theft law, which says you can't retain earnings longer than they are due. So if you have property and it hasn't been returned, and this person's been fired, keep in mind, you do have to pay employees immediately upon termination rather than quitting under Colorado law. You're going to have to immediately initiate a statement to your employee that they have unreturned property, and you are at least going to withhold under this law until they've established their return of the property. And that's important for people's consideration. It does require administrative machinations to try to comply. Natural medicines approved. I wanted to mention this to you. Please be aware. Once again, goes to the issue of what is going to be the employer's perspective on drug testing, drug compliance. So now magic mushrooms are lawful to use and possess under Colorado law. And therefore, employers are going to have to once again relook at what is the fitness for employees if they have access or use these particular lawful substances. Please keep in mind, though, that there's nothing under the Natural Medicine Health Act, which was approved by the voters last election, that says an employer has to in any way accommodate or permit the usage of these products. And therefore, we can still enforce our pre-existing drug rules, drug testing protocols, and it's still illegal under federal law to potentially use or possess these substances. And therefore, they could be met with disciplinary action under Colorado law. But it does require us to once again look at what is the appropriate measure of our examination of employees' drug use, given the fact that more and more of these substances, medical marijuana, recreational marijuana, and now mushrooms are lawful for use under Colorado law. Let me just do a few more rules. I want to make sure I leave some time for questions, but I got to get through this part, and then you can read the remainder of the slides at your own and certainly reach out with questions. Our rules are tricky. So just so you know, relatively quickly, let me make sure I establish, we have a new minimum wage, goes up every year or goes down based on the Consumer Price Index. Now it goes up to $13.65, significantly higher in Denver if your business is in Denver. And to be an exempt employee and remain exempt under Colorado law, unlike federal law, if you're a non-governmental entity, an exempt employee has to be paid at least $50,000 a year in 2023 to maintain the exemption. And that's important that people understand that. We talked about the Healthy Family Workplaces Act. That is the requirement of 6 days of paid sick leave every year. We have guidance here, which is helpful for employers, that says you don't get to accrue more than 48 hours, that if an employee doesn't use their 48 hours of sick leave, they don't get any additional amount. The unused sick leave goes towards next year's Is this the term? I have to look at it, but it probably is, Chris, just so you know, if you got it online. It's pretty widely available, and it has a number of boxes for you to check in terms of what is the basis. You don't have to specifically say it, you just put it into a box. And then, of course, please keep in mind, public health emergency leave is up to 80 hours, and you can use all or part of the unpaid paid sick leave towards the 80 hours of public health emergency leave. I want to remind you, it's a one-time public health emergency leave during a public health emergency. A couple things about that, just different calculations on pay. Don't want to delay the class based on this, but the paid leave is based on the employee's compensation over a 30 calendar day period. And that's how we assess for employees that have differing wage rates on what we pay them. Public health emergency is still in effect. I wanted to get to this slide. So remember, we talked 2-3 years ago about this. Colorado adopted a public health emergency leave effective January 1st of 2021. And you could use up to 80 hours for any public health emergency and related to a public health emergency. The public health emergency is still in effect under federal law and is not going to end for Colorado use until at least February 8th of 2023. So I did want to remind you of that. What's even more important is Governor Polis has said, at least in November of 2022, that employees could use their 80 hours of public health emergency leave, not only for COVID, but also for RSV and the seasonal flu. So if your employees haven't used public health emergency leave, they could use it for RSV, COVID, or influenza. It's a one-time use though. They've already used it, then they don't have eligible time remaining to them. Next one's commissions and bonuses. It is now unlawful under Colorado law to have a must be present to win bonus or commission. What do I mean by that? Is many employers have bonus provisions that basically say you must be employed on March 1st to receive your 2022 bonus. And if an employee left or was fired before March 1st of 2023, you must be present to win. Therefore, you do not get your bonus or commission. No, it's not how it works under Colorado law. If they earned the commission in 2022, and you can reasonably calculate that vested determinable amount, then you can't have a must be present to win clause to prevent anybody from getting a bonus or commission in their compensation. That's where I want to leave you at. The remaining slides are about just interesting cases I had over the course of the last year. Don't want to take more time than we've devoted. You've been so attentive with your questions. But if you have any questions on what we've talked about, I did want to leave a few minutes for that. And you were game with the questions you've asked thus far. Any questions before we end our class? And please review the slides at your leisure. Please reach out to me if you have any questions about any of the slide content. And it's important that we have these conversations, but I really wanted to hit the Colorado rules for you to be attentive to, because as you can tell, there's a lot of them this year. Let me leave a couple minutes here, and thank you for the compliments. I appreciate it. Yeah, I still understand public health emergency leave. Good for you. Tremendously complex. It's that 80 hours, and the 80 hours is an additional benefit, meaning if the employee does not have any accrued paid sick leave, you had to pay 80 hours, up to 80 hours. It's proportional for part-time employees, but up to 80 hours of pay for public health emergency leave. And many employees used it during the course of COVID, but if they've used it, they likely, it's no longer an issue with regard to them. But as you probably know, Chris, there will be more public health emergencies, and there will be more availability of the use of this leave. The PHE, is that still on the company to offer that as a benefit and pay it out? It remains in effect. The public health emergency under federal law goes through January 12th. It may be renewed. I got to look at the got to look at the Department of Health and Human Services website today because the public health emergency under federal law has continued until January 12th. I haven't seen if it's been renewed. And under Colorado law, you can use public health emergency leave 4 weeks after the end of a public health emergency, which takes you into February 8th specifically. Is it available every year? No, for public health emergency leave, it's a one-time shot. Now, paid sick leave, 48 hours, is available every year. And so they get 48 hours. Sick leave you can carry over is up to the 48 hours. So if I've only used 3 of my 6 days, then next year I already have 3. You need to allow me to accumulate 3 more days of paid sick leave. And of course, employers can always be more generous when it comes to paid sick leave, and many employers are. It's important that people recognize that fact. But employer pays those PHE 80 hours. Absolutely. The public health emergency leave is an employer sponsored and paid benefit. So that 80 hours is above and beyond potentially any other paid sick leave. You can use existing paid sick leave towards that PHE threshold though. And I want to make sure you have that. If you offer paid sick leave, and you must in Colorado, part of the 80 hours is the paid sick leave the employee has if they've not used it already. If your company has PTO, do they still have paid sick leave in addition? There's a rule about that, Heidi, and that is under Colorado law, you can have a PTO policy that covers the paid sick leave requirement. But here's the rule. If you have PTO, the PTO benefit has to allow for the exact same reasons for the use of paid sick leave as Colorado law. And it's important that people recognize that fact. So your PTO benefit has to allow all of the same time off protections as Colorado's paid sick leave law does. But you can use PTO to meet Colorado's paid sick leave requirement. So I do want to make sure that people know that.
Thank you so much, Chuck. You did an amazing job. That was a ton of really helpful information, as the chat has indicated lots of questions. And so I'm sure this is the start of conversations for many of us within our organizations, and maybe needing to use you as a continued resource as we all navigate this year. For all of you that are still on, we will circulate the recording as well as the slides after this session. It usually takes a little bit to get it uploaded from Zoom, but we'll get that out to you either later today or early tomorrow, so you have access to it. If you have any questions or need anything further, please feel free to reach out to myself at the Arvada Chamber. It's Cami at arvadachamber.org, and we're happy to get you what you need. Thank you so much and have a wonderful day. Thanks again, Chuck.
Yeah, please reach out. My contact information is on the slides, and you're more than welcome to contact me after the class is over.